Bam! First case lasts barely 40 seconds. Tenant no-shows, no written response, and the judge issues a judgment for possession on the spot. That means the landlord can reclaim the property in 10 days with no redemption amount. Lesson 1. In housing court, silence is basically a self-eviction.
Charel Barksdale versus Leo Stringga. Your name?
Charel Barksdale.
And Leo Stringga, not here. This is a termination of tenancy action. He also did not file a written answer. The defendant, having failed to appear and comply with the court's orders, judgment for possession will enter. There is no redemption amount. Writ will issue in 10 days. For my signing. So you'll need to fill out a judgment for my signature. Get a copy at the front counter.
Okay, thank you.
All right, thank you. Take care, Miss Andula. Court calls the case of Stean Weaver versus Eric Buckner. Is this one of Miss Lee's cases? Oh, and Nicole Winnable.
Good morning, sir.
Good morning, sir. Your name?
Eric Buckner.
All right. Where are we on this case?
Mr. Buckner and I.
Now we pivot to Eric Buckner, and the judge is crunching numbers like a human calculator. They agree to pay $1,000 today, then $700 every Tuesday until a $7,400 balance is gone. Conditional dismissal means if one payment is missed, the landlord files an affidavit of noncompliance and, boom, automatic eviction. Would you gamble on weekly payments or just pack up now?
I have agreed to a COD, which I will submit on the 7-day rule. Should we include the terms as to his wife, who is Ms. Winnable, as a default?
Yes.
And then she's in default, and if we have to come back. So, Your Honor, we agree that today's balance is $5,100.
Okay.
We agree that monthly rent is $2,300. They are going to pay $1,000 today, $700 next Tuesday, and $700 every Tuesday until their balance is zero, but no later than October 31st.
Got it.
So it'll be a total of 51 plus 2,300, which is $7,400 that they'll pay. 1,000 today and then 700 a week until it's paid. They'll pay their monthly rent on time through the end of their lease, which is March, right?
March. Yeah.
Which is in March. We'll do this as a conditional dismissal. If they comply with those terms, then matter will remain dismissed. If they don't, the landlord is entitled to submit an affidavit of non-compliance, a judgment, and an order of eviction.
Sir?
Yes, sir.
Is that correct?
Yes, sir.
All right. Do you have any questions regarding those terms?
Nope, I'm good.
Okay. When I do sign it, and I just will advise you, since your portion is really a consent, that you would have 3 business days in which to think about it for the date of my signing. If you believe that there's some legal reason, some right you didn't assert, some misunderstanding or confusion, you'd have to file a motion with the court within those 3 business days. You understand that, sir?
I'm good.
All right.
Thank you, sir.
Thank you for working
Great
it
day.
out.
I will.
Thank you, Your Honor.
Yes, thank you.
Karen Steele versus Robin Yash.
Maybe approach. Can we approach, Your Honor?
Oh boy. Yeah, come on.
Thank you.
Did you catch that? Even after signing, tenants get 3 business days to challenge the deal if they think there's a legal glitch. It's a tiny lifeline, basically a cool-off clause, but you'd better act fast.
In this matter, record should reflect the defense conference with counsel. Really, but surely things are kind of coming through, and I don't mind giving the parties an opportunity to try to get themselves closer. In October, final settlement conference date.
October 14th.
14th. Will October 14th work for counsel?
Yes, Judge.
Works for me as well, Judge.
Okay. So final settlement conference will be adjourned in this matter October 14th, 2025, 9 a.m.
Thank you.
Thank you,
All
Your
right.
Honor.
Thank you, folks. Thank you. Lori Anderson versus our money line.
Your Honor, for the record, Tish Lee for the defendant, Precious Turman.
This is okay as long as he orders it. Your Honor, I think we have a conditional order of dismissal. I thought I did that when you first called it, James.
Judge calls for a private bench conference. Classic move when lawyers need to hammer out terms off mic. No fireworks here, just strategic whispers that keep the courtroom clock from exploding.
For the plaintiff.
All right.
Do we want to approach the bench?
Sure.
Okay.
Maybe.
Yes.
Just take a minute. Your Honor, we will submit a conditional order of dismissal that dismisses this case subject to the terms of the order, allows Ms. Turman to retain possession of 833 Armstrong pursuant to the terms of the lease agreement, provided she complies with the order. Her rent due as of today is $2,969. That's rents, costs, and fees. That's her ledger balance. She will pay $98, which is her September rent, on or before September 30th. She will pay the remaining balance after paying that 98 in 6 equal payments commencing October 1st, 2025. If it's the entire balance.
Enter Precious Turman's case. A 365-day conditional order with more subclauses than a cell phone contract. 6 monthly arrearage payments, annual recertifications, waived objection periods. This is housing law as Excel spreadsheet. The key takeaway? If she follows every line item for a full year, she keeps the apartment and wipes late fees.
It will be $478.50 a month, 6 equal payments for the arrearage, but we expect that she's going to get assistance. And so whatever the balance is going to be divided by 6. That's what she'll pay for those 6 months. It could be as low as $50. She'll pay her monthly rent on time and not later than the 5th of each month. She will timely complete all recertifications, both annual and interim. While this order is in effect, she'll comply with the terms of her lease. If she makes all payments as agreed, no additional late fees shall be added to her ledger. My client can only do that if you order it. And I know from our previous discussions that you would order it. So we added it. If she's delinquent, late fees will accrue. If she fails to comply with any terms of the order, we can file an affidavit of non-compliance with a copy to defense counsel. They have 5 business days to file objections. If they object, you'll have a hearing, and it will be based on a preponderance of the evidence, except as set forth in this. The terms of the lease continue. The 14-day objection period of MCR 2.602C2D is waived. The 56-day rule is waived. This order is good for 365 days for enforcement. There's no admission of or a finding of fault or wrongdoing. Court retains jurisdiction, and this is a final order resolving the last pending claim.
All right. Is that a correct statement? Here's the only issue that I have. The additional payment is due at the same time as rent.
Watch this subtle but tenant-friendly move. The judge shifts arrearage payments from the 1st to the 15th of the month. Why? To give breathing room when rents spike after a recertification. It's a rare moment where judicial pragmatism meets compassion, proof that timing can make or break a payment plan.
I have a problem with that. I would rather that the additional payment be due the 15th of the month. And my only reason for saying that is because I just ran into this. I thought about it before, but it just ran into it where they do a recert, the rent goes up, and then there's this huge amount at the beginning. It can be paid if there's like another paycheck.
I'm sorry, Your Honor, they do a recert when?
The person did a recert. There was a recert done. Their rent goes up. They had this lump sum payment due. All of it's due at the 1st. And so their rent went up, and then all of a sudden they had this large payment, this payment due.
The arrearage payment.
Right,
Made that change, Your Honor.
okay.
It's the
It
15th now,
just,
so commencing October 15th and on the 15th of each month for those 6 monthly payments on the arrearage.
I just think it's easier for tenants
Got it.
to
Got it.
do.
So instead of starting on October 1st, it would start on October 15th.
Okay. I mean, if she wants to pay it early, she can. I just don't want them pinched into a box. Are all those other terms correct, Ms. Lee?
Yes, Your Honor.
All right, very good. Thank you, folks, for working it out.
I just sent it to Ms. Wyling and we will sign it and submit it today.
All right, fantastic. I will
Thank
mark
you.
this file conditionally dismissed. Thank you. Thank you, Ms. Turman.